Someone's asking if there's ever a need to go back to Michigan. Yeah, it's lovely in the summer for about 3 months, and I have family up there. So, yeah, I used to talk stuff about Michigan. Then I went back there a summer, and I'm like, oh my God, I forgot how beautiful it was. Hey, are you able to hear me? Thank you, Jeff. Are you able to hear me? Check one, check. Hmm. Well, here we are, and I guess I should say something. I'm just looking into the screen here. And I'm being told it sounds great. This is our second conference Q&A. The first one was just fraught with technological problems, probably because of me, and nothing to do with Michigan. A gentleman had just asked, why would I ever go back to Michigan? I go back to Michigan probably 1 or 2 weeks a month. I go back and forth. My kid's up there, so I'm always happy to go up there. Aloha to Mary. That's cool to say that. Speaking of nice places. Um, if anybody has any questions, I'll entertain them. Just as a side note, well, not as a side note at the beginning, I'm here to answer any questions you have about how I do what I do, and hopefully you can incorporate whatever. If you hear something you enjoy or reference to any documents, you can incorporate into your state rules and application. You're my friend, not my client. And act accordingly. That I have to say at the beginning, and my need to help is overwhelming. So I will try to get to everybody's questions. And what I will do is try to repeat them and then answer them. I think we are recording this, and I want to so that it is helpful to others that I weren't able to attend. So if you have any questions, feel free. Until you ask, I'll just ramble. Um, my latest ones this week have been these weird trust debt buying companies that have just flourished. I don't know if I did a good job telling you about the fintech explosion. There are these companies that align themselves with banks in certain states that allow, how do you put this, to go beyond the usury laws, which prevent people from being charged enormous amounts vis-a-vis predatory lending, that type of thing. Some states are looser. So these companies go into those states, and this is a very simple way of putting it, and align themselves, operate in that state, whereas normally you couldn't because of the usury laws. And then the partnership produces a securitization, which has its benefits and its reasons. This may be the other reason, as far as maybe hiding things a little. And then the good thing for consumers that are being sued by some weird trust company, is because of the nonsense at the beginning, allows you to give the bad debt buyer the nonsense at the end. Somebody's asking, Kenneth is asking, are the rules regarding the affidavit being prepared 10 days within the date of filing lawsuit? I understand what you're asking. Every state has a different rule. In Michigan, MCL 600.2145 requires, and the statute is horribly written, so it's up for interpretation. But the way I see it is a couple of things that are good. Very briefly, a number of states, including Michigan, have this rule that if you don't answer the affidavit that debt creditors attach to their lawsuits, there is hard, fast rules and case law. Fisher is the case in Michigan that says failure to answer a counter affidavit is presumptive that you owe the indebtedness. The only thing to talk about then is how much you owe. So you lose on liability by not answering. So that's why I'm so hard into the counter affidavit with you all, depending on regardless of what state you're in. So Kenneth is asking about the 10-day rule. The way I read it, it's at the end, at the very end of the statute, it says, you better answer this in 10 days. And that's aligned with this other cool thing. If you notice my recent counter affidavits, they all say, hey, you owe me $6,000, debt buyer, debt collector, if you don't answer this. And very clearly, probably the most clearest part of that statute, which goes on and on for paragraphs, is if you don't answer the affidavit, you lose. However, the statute also says if you file a counterclaim with this counter affidavit and they don't respond, they owe you. So I'm throwing that in there just the same way. It's good for the goose, good for the gander. But at the end of the statute, it says there should be signatures within 10 days of the filing of the lawsuit. So rarely does a debt collector have a signature on their affidavit within 10 days of the lawsuit, especially with debt buyers, especially with MCN, especially with PRA, especially with LLVNV funding, because it's a giant machine. So MCM, for example, has an office in Minnesota, been there. I've deposed the affiants that just pumps out tons of affidavits with no knowledge of what they're going to be attached to or when the lawsuit. Then let's say the lawsuit's in Michigan. There's 3 law firms that do MCM lawsuits. They get that affidavit. They write their complaint. Excuse me. The complaint, I believe, is also written in another state. The attorney hopefully reviews it, signs his name. There's no way with all that mechanism and machine and thousands of these, and there are truly, that they can meet that 10-day period, get this all done, put together, and then filed with the lawsuit where the summons has to say filed. Look, when you file a lawsuit, and these days you send it by mail or overnight mail, they need 3 or 4 days to have it filed. So there's that 10 days window is shot. So just about all affidavits, unless you're personally serving and creating all your own documents near the district court, there are 1 or 2 companies that do that. They're going to break that 10-day rule that Ken's referring to. So I hope that answers the question, Ken. If it doesn't, go right ahead and yell at me. Statute in Michigan is MCLA. Ken is following up. What's the statute? It's MCL 600.2145. Again, I think it's called Fisher-Sims. I want to go online, but I want to mess this up. Fisher-Sands. So go to the Fisher-Sands case if you're looking at Michigan, for the Supreme Court of Michigan decision. And it's right there. It's better than going to the statute. It'll tell you, because the defendant failed to answer the counter affidavit or just respond to it, automatic failure. I really want to go look at the statute and quote it word for word now, but I just don't want to mess with toggling this nonsense. So that's that. Mary asks, is there a way to write a settlement that blocks others from suing on the same debt, considering no one is listing full? Yes, absolutely. It's called, you can write anything to a settlement offer. You can write anything into a contract. You can contract away all your rights as long as it's a public policy to do that. Like you can't say, I'll pay you $5 if you go murder my sister. That's against public policy, all right? That's against the law. But you can sign away rights that you have for money, for forbearance, for reasons between you and the contracting party, as long as you have a meeting of the minds, offer, acceptance, consideration, and signing, yada. So Mary's asking, is there a way to write a settlement that blocks others from suing on the same? Absolutely. It's easy. If you are writing by the way, usually when there's a settlement signed, you consumer are receiving one from the collector, and then you shape it with the things that you want, and you both have to agree. But generally they're providing a template. But a case that is filed with prejudice has the effect of two things that are healthy and good for you. Number one, with prejudice means you can never be sued on that debt again. Case closed, so you can't be sued on it. Number two, and I've done this, even if they don't take it off your credit report because they can't because of FCRA or some reason, or they just won't, you've been sued and you dismissed it with prejudice. I would attach that to my dispute letter and say, why is this on my credit report? It's a pursuit of me. It's a collection effort. The debt is expired and you can't do this. And that works. 100%, I don't know, but it's certainly there for you. So you can write into any agreement, consent order, settlement, and how you do it in a consent order, they would say, we are the true owners of this debt. We are releasing you, discharging you and your heirs and all that. That's good enough. So that's it. As long as someone's saying they actually own the debt, and as long as there's a dismissal with prejudice, voila, you're out of the debt, can't be sued again. 1 out of 100 cases do resurrect again. I call them zombie debt. And usually zombie debt's like 10 or 15 years old, but 1 out of 100 cases. I've had cases where I settled with, I can't say, a student loan organization, and it showed up again with a debt collector that somehow had it. Turned out those two had a relationship, and there were so many cases and so little organization. I ended up getting my same client that had resolved the case a bunch of money because it showed up again. And Exhibit 1, dismissed with prejudice. Here you go, court. So that was a nice. She wasn't happy, and it makes me look bad too because it looked like I wasn't doing my job, but she was happy when we smacked them. So I hope that it answers your question, Mary. You provide great advice, Kenneth writes. Have you found that the implementation of said advice is viable for non-attorneys? If you remember, go to the community forum we set up. There was some nice stuff on there. Somebody said that they recognized my work that they were using. An attorney against me recognized the work that she was doing. I won't mention names, but it's on the forum. And they said, wait a minute, is this Brian Parker? And they complimented me, even though they're on the other side. And she was a little scared about what the future brings, but I kind of told her what I think is going to happen. Those documents are not me. Those documents are more powerful than me. That's 30 years of the DNA of my former clients, of my hard work, of my sweat and tears, of my fears of losing, going into everything I write. It's the very latest stuff that I can do. I'm always thinking how to do it better. You could look at even within the small time I've had the membership website and look at some of my affidavits, and the most current ones are much better. Not better, but more in detail. I'm always thinking cool things to trip. How do I get that? Because when you start doing this a lot, you see different people, you can trip them up different ways, different firms, different approaches. So if I'm going after a particular collection agency, either for verification of a debt, I'll throw in some extra stuff that I know really bothers them. Capiche? Or if I'm going after a company, I know how easy it is. If I just say the right words, that'll be in the affidavit, validation request, impermissible purpose letter, request to admit, whatever it is. You know all the soft and sweet spots, and I give them to you. I hope that doesn't sound too risque. Okay. I hope that answers your question. So Mary says, yes, you did answer. If anybody has any more questions, I'm not a radio person, although I have a face for radio. I do know dead air, and I don't want dead air. So if you have questions, go ahead and ask. And when I say that, for anybody that's viewing this, I think we're recording, I'm looking at a chat screen. I don't know if it's coming up, but I'm trying to repeat the question and then give you the answer. Next week, I always have an eye on two things. So I started doing this YouTube video stuff, let's say 8 months ago. I'll be very honest with you why I did it. I'd always wanted to do it. And I was itching. I love to teach, and I have a little bit of an ego, but it's turned out it's not been ego centric at all. I love it. And creatively, it's the best. And the feedback I get from you all, it reaffirms that I'm doing the right thing, what my life is supposed to be doing. But I will be very honest with you right now, because I think being personal is the best way to go. I had just come out of the worst, the worst relationship breakup I'd ever had in my life. And I didn't know what to do. So this was, other than analysis and reading and learning, this was cathartic. And you can see in really early videos of my YouTube extravaganza, I'm a man in crisis. I'm not that way now. Now I smile all the time, but I looked at old videos and go, oh my God, I didn't realize I was so down. So that's the reason I started this. And now it's just fermented and matured and evolved into, I'm where I'm supposed to be. I love helping people. I put all this stuff for free on my website, but it was becoming overwhelming. I was not comfortable charging, but I started this membership thing and people were yelling, what are you, crazy? Charging that. You should charge blah, 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 blah. So it creeps up, but I don't want it to take away from the number one thing that turns me on. The creativity of it all, and how when I learn and when I write down the show notes, I get another idea. So that goes into the counter affidavit or the motion or the answer. So I love this stuff, man. I hope it comes through. And I have an ex to thank for it. Okay. Do we have any questions? Received an answer from the Jillian. Jillian asked, I received an answer from a counterclaim sent. Okay, I got the responses are separate defenses. How would one respond? All right, great question. What she's asking for is, in Michigan, it used to be, Florida, some states, if you sued someone, they answered with affirmative defenses, and you should always have affirmative defenses. Remember, it's like you snooze, you lose. You've heard that. If you don't file affirmative defenses, you waive your right, and you may need them. Evidence may evolve where you go, shit, I should have defended a certain way. Now you can't in your defense. Well, there was a rule that said if someone files affirmative defenses and then you counterclaim, you can say, I'd like a reply to my affirmative defenses. It just goes, it's like a Pong game. So they sue you, you answer, you file affirmative defenses, then you write under them, I demand a reply. And if you don't, it has rules and legal consequences. They did away with that because of the ping pong, back and forth. But I kind of liked it because what it was trying to do is, lawyers are boilerplate a-holes. If they need two things to write in a contract, they'll write 57 because A, they can bill for it. B, they're scared, insecure by nature of their profession to screw something up. So you cover your ass. It's like NASA, the redundancies and unnecessariness of it. So the reply to answer to affirmative defenses is a quirky, insecure approach that has been cleaned up a bit with the changes under Keep It Simple, Stupid. And so that no longer has legal consequences if you ask someone to reply to your affirmative defenses. So look at it this way, back to your question, Julian, because I'm way off the rails. If you sue someone and they answer just like you did to them and they have affirmative defenses, they can do that. Just like when you answered, you had affirmative defenses, because a counterclaim is a lawsuit. I've had plenty of cases where I won the underlying case, but now the counterclaim exists. It still exists. It's the same. It's just like a lawsuit. The cool thing is, and here's a tip, when you counterclaim, when you sue someone, you got to pay your 2 bits. You got to pay your filing fee, your jury demand, this to sue. But if someone answers and counterclaims, in most states, you don't have to pay, even though it's an actual lawsuit. Florida, I practice in Florida too. They make you pay now like it's a lawsuit, which logically makes sense, but a lot of rules don't catch up to the way things are. But it's going to be a fee that most states will latch onto to get more revenue when somebody realizes that the counterclaim is just like filing a lawsuit, because it is. I hope that answers your question, Jillian. Mary asks, Judge seems on autopilot for summary judgment. Great insight. Excellent. Because that's true. For plaintiff, yep, that's right. Was filed in wrong court and counter affidavit was never responded to. Excellent. If you filed a counter affidavit and your statute in your state allows, two things. Go in and say, default, they didn't answer the counter affidavit. Just do actually don't do anything. There's an expression, keep it in the weeds, stay in the weeds. Young attorneys don't understand the concept of being in the weeds. And how you can recognize when watching an attorney work, if they ask the question why, and they shouldn't have, young attorneys ask too many why questions they don't know the answer to. Older attorneys with gray hair like mine love the why question as a curiosity, but will never ask without kind of knowing the answer. And that's Perry Mason 101. So stay in the weeds with that counter affidavit. Don't, now that I'm talking with you, don't do anything till you can strike when it's most useful. And that will be in your summary judgment response. Number one. Number two, let's have some fun with the judge. What I do is, let's say you've answered the lawsuit. The assignments are screwed up. There's no proof they own it. And generally 99% of the cases, that is the case. 99%. So you know the summary judgment's coming. It's probably an old-time judge, just wants to move him in, get him out. She owes the debt. Why is she complaining? You know, that type of crap. But the question is, who owns the debt before you get to, does she owe the debt? So here's how you bust some chops. And you're going to go in the weeds again. This is what I do. I'll ask through discovery for proof of the assignment between original creditor and the plaintiff that's suing me. They'll give you some BS that doesn't mirror a true assignment. And there's plenty of case law showing, depending on your states. So now you go, hey, you go to court and you go, judge, motion to compel, they have to provide the assignment. She's going to go, yeah, you do. She's not thinking like you think she is about that summary judgment coming up. She's just thinking, oh, motion on my docket. She'll go, let's say it's LVNV funding. You got to prove that you've got a true assignment with the account number and the account number and the person, the debtor, between Sherman Acquisitions and LVNV. There's an order that says they have to do that. It will not come. Wait on that. Now they'll file a summary judgment, and you keep this in your pocket. Well, you just got a judge to say you got to show the assignment. In other words, she sold on your argument about the assignments in a small motion where she's not thinking big enough to the upcoming summary judgment like you are and they are, but the judge isn't. It's just another case. So when it gets to summary judgment and you present in Exhibit A her signature of an order saying, where's the assignment? She's screwed. Screwed in that I wish her no harm, but like you said, with the original premise of the question, if it is, she's got her eye on the summary judgment and kicking your case, you just nailed her. She can't go against her own order. So keep it small, keep it simple, keep quiet, file your motion to compel without any thought about the summary judgment, because when it happens, she can't rule against herself in a sense. I hope that makes sense. If it isn't, follow up. Mark says chat is not working. So far, everybody's asking me questions and saying, yes, so smart. Okay. I have a self-esteem problem. So if you tell me I'm doing well, I won't believe you. So ask for dismissal ignored, ask for validation from both creditor. But that's all great stuff. As I said in a video 2 videos ago, clients will go, why send that letter? They won't respond. But a non-response is the best answer, second best answer. First best is they send you the wrong stuff or lies. So as I said, Green versus PRA, it's wonderful. It says right in the case. It's like someone wrote a cookbook recipe because it's a Virginia case. It's persuasive authority. It may not be binding on a state, but it's persuasive. But the cool thing is, it came out of a podunk court, not podunk, but not climate change affecting or nationwide. But the Virginia court took it and brought in Ohio cases and these cases. Some of the cases I recognize, I've used them. Georgia cases, thus strengthening its nationwide appeal. And it said right in the word, even if Miss Green failed at her ability, not failed, but the fact that she asked PRA to validate the debt before all this mess began and they did not answer is against them. They lose. So, yes, you sometimes want them not to respond. Don't do anything to make them not respond, but don't be scared of a non response because it's just as valuable in some cases. I hope that makes sense. I'm going to say right now, and I'll probably be ignored because who the hell wants to read cases? Read that case. It's long. If you have to read a page a day, fine. Get your highlighter out. If you just want to go to words that say, in sum, we conclude, or you want to go to we hold, or it says in other jurisdictions that support our decision today, then look at those. It may be one of your cases. So you may have, it's a Virginia case and you may be in Ohio going, it's a Virginia. There's an Ohio case in that. There's a Georgia case in that. So and it's again, persuasive authority. If you have a state that is on the fence about is an assignment, what's an assignment, should, but the court will listen. It needs help. It's persuasive. That's why they call it persuasive authority. Okay, yes, so smart. Yes, the case. That's great. Mary just can't leave me alone with the compliments. Thank you, Mary. Good, we got what you mean. Aaron says, yeah, that PRA case was a juicy decision. Someone actually listened to me? Wow, as one. Okay, been helping Kenneth says, been helping consumers since 1993. I love your kind of effort, David, strategy. Also, the borrowing. Yeah, Ken and I have been going back and forth on that. I love the borrowing statute too. I'm a fan. I'll tell you why. It usually benefits me. Someone will come into, let's say, Michigan with a Texas statute or a Texas case, and they'll take a foreign judgment or they'll file a case. And under certain factual circumstances, the borrowing statute says you go with the statute of limitation, I think, for the consumer or the state it came from. But the borrowing is you're borrowing somebody else's statute of limitations, usually to your benefit. If it isn't to your benefit, you don't bother with the borrowing statute. But so that borrowing statute is cool in that it borrows somebody else's statute of limitations to defend against a case because I'll tell you what the premise of all that is. Michigan has a 6-year statute of limitations. So these crafty debt collectors, they are on top of everything. You ever say to yourself, God, that criminal is smart. If only they did good and they put their powers to good. That's a common expression. Well, let's say you're in a 4-year statute of limitation. You got this debt and now the person moved to Michigan that you want the money from. I'm going to go to Michigan and file it. They got a 6-year statute of limitations. It's only 5 years later, even though the case they came from and the case the case can't be sued upon. They'll go in and take advantage of the highest statute of limitation. So the law is, we're going to borrow from the place where this came from. And that's a general approach. Thank you. Aaron, you're right. It is juicy. Miss Green, who is the person that was sued and supposedly owed PR, is a pro per. So going back to the original question that was asked, let me repeat the question. If I can find it, yada, yada, yada. You provide great advice, asked Ken. Have you found that the implementation of said advice is viable for non-attorneys? Answer. Check it out. PRA versus Green. Enormous case. Miss Green, Maisie Green is a pro per. She did all that herself. I've checked out the attorneys that were representing PR. PRA knew how serious this was because they brought in some money, like serious attorneys. She beat them on her lonesome, pro per. She's a pro per defendant or person. So that's the answer, Kenneth. Is this stuff any good? Yeah. And look at the circle of it. Now I'm using it as an attorney, giving non-attorneys advice. I'm a conduit. That's what I am. I'm a conduit. You cannot get to planet Jupiter without finding a way to bounce off Mars. I'm Mars. Jupiter is the promised land for you with assignment cases. The Earth, that's where you're coming from. So Maisie Green did good for all of us, attorneys and pro per and self-represented people. I hope that makes sense. What do we got? Cynthia London. That's a great name. Could anything be done about a charge off on your credit report from a debt that you were not contacted about being in default on? How do you prove they didn't contact you? Whoa, how do you prove a negative? That's an English major lawyer question. Fun question. So there's a couple of questions. Can you do anything about a charge off in your credit report from a debt that you were not contacted about being in default on? Well, if it's not your debt, yes, the dispute mechanisms. If it's your debt and the issue is I was not told I was in default, meaning I am making regular payments, so why would I be in default? Yes, you can, and the FCRA approach to it all, legally, let's say XYZ company put a bad debt on your credit report. You don't send a dispute to XYZ. You send a dispute to the 3 credit reporting agencies. They're reporting a bad debt and should have done their homework. They're going to point the finger at XYZ, but that's on them. And then number 2, there's a mechanism just to sue on a furnisher case. FCRA, a furnisher case, B2B, I think it is, 1681, you fill in the rest. And it's a furnisher case. You send the dispute notice to the furnisher, meaning XYZ, the guy that gave you the credit, guy or gal credit company. But I don't do that. I include everybody. And what's the rule? Belt and suspenders, baby. I let everybody know and let them all work it out because the goal is to get it off your credit report. So the credit reporting agencies may say, uh-oh, we're in trouble if we don't get, and I've had cases where my client disputed and they just dropped the debt without arguing, because it's cheaper for them to drop a debt sometimes. It's pragmatic than and when they get a whiff that there's an attorney involved or you've done the dispute right, they'll just drop the debt. Act accordingly. I hope that answers your question, Cynthia. Now we've got commentator beefs. Can Cynthia use your validation letter? Is it too late? Asks Aaron. It's never too late. That's a great question. I've been asked that before. It's past the time. You only got 30 days. And I'll tell you why, for many reasons. I'm always sending a validation letter because remember I talked early in this video about things that aren't necessarily black and white rules. Debt collectors get really scared about the FDCPA regulations and will just out of fear answer it. Like in the Green case, Miss Green is sending that validation letter on the cusp of a lawsuit. They probably notified her way before then, and that 30 days that the statute talks about is over. The CFPB, which is a federal agency, was really good a couple of years ago when it first started. it's kind of been gutted because of one of the administrations that was favoring business. But they wrote a rule changing the validation approach in November 31st, 2021. And now they said to credit reporting agencies, here's a model letter to send folks when you're sending them their validation rights. Now, you've heard the expression sleight of hand. So you're being led to think that the Consumer Protection Board is on your side and they're making now the debt collector send out more information so a person can make a good decision about whether it's their debt or if they're going to pay it or if they're going to dispute it. But the sleight of hand, this is such a business decision. Is you're thinking as a consumer, wow, they've set up this situation where they have to give us more information. But the letter is a model letter, and the federal board, the Consumer Protection Board, said use this letter and you won't get into trouble with jerks like me, FDCPA attorneys. All it is it gives you 3 boxes to check off. I dispute this. I don't dispute it, but it's the wrong amount, or I don't like climate change. Whatever the 3 boxes are, but it limits your ability to dispute the debt to 3 boxes. And so we're told, hey, this new law is great. It gives us more information. But that's the carrot, and the stick, which is being smacked on your head if you follow this, is that now you're limiting your dispute response to a checkbox. So this letter, and it says, don't even write a letter. Just use the same letter, the form letter that all collection companies use and send you now. Just and tell them to send it back. No, you want a detailed explanation of why you don't know it, and the law and the statute and the FDCPA regulations. By the way, securitization, whether anybody likes it or not, is the most prominent basis of debt and why you don't owe a debt today. I'm not being it's not hyperbole. It's quite logical. And that's not in the letter. So how are you going to get, if it was securitized and LV&B Fund is sending you one of these letters and that twist and turn through securitized tranches so you don't owe the debt? That's not on the letter. You write your own letter. Don't respond with this seemingly great thing that the CFPB, Consumer Federal Protection Board, I don't know what it is, but again, I'm not going to check it out because I'll screw this whole thing up. So I hope that answered the question, and I'm writing on what Aaron was talking about. Write your validation. Use one of mine, please. But I'm not telling you how to live your life. So, okay. Anything else? I hope that answered your questions, Cynthia. The default, you would know if you haven't made payments on it. So if you have made payments timely and someone's saying your default, so understand how a thing lands on your credit report. There's 2 bars it goes through. So when you're delinquent, you default delinquent, 6 months passes, and probably Aaron will be a better teacher of this. But 6 months, you have to wait. Someone has to wait 6 months, and then it's charged off. So they operate in 6-month intervals for whatever reasons. So if you don't know, or you did not default, and by the way, on a credit reporting listing, it'll say was late or missed a payment or yada yada. So if you're completely green or check marked as making all your payments and they charge you off, that's exhibit 1 right there. Why are you getting charged off or even defaulted when the credit reporting agency is reporting you've made every payment? Excuse me. So I hope that answers everybody's question. Jeff is helping out. Consumer Financial Protection Bureau. Great. The freaking attorney doesn't know that. What a dummy I am. But I mean, there's letters flying everywhere. I'm sorry. When I'm on camera, I get nervous. I knew it when I started this soliloquy and I just go off the rails. So anybody got any more questions, or shall I fill the dark air, the dead air? Hats off again to Kenneth, who's been helping consumers since 1993. I thought after creating this membership website, I started getting calls from debt settlement companies, and they were asking questions. Like, I would just go to video one, and then one day, some company said, "Could you come in and handle our hard cases?" Like, oh, okay. They brought me in a meeting, and it's just, you know how Zoom is. It looks like the Brady Bunch. You got like 9 people on the screen, and so we're going forward, back and forth. I'm boring, blah blah blah. I said, well, on my membership site, and I watched visually all the people that were asleep wake up, and they did not care about protocol. They all yelled, "I'm a member, I'm a member, I'm a member." I thought, aha, this doesn't just have application for consumers that's my focus. There are debt settlement companies that don't even have to train their clients anymore. If they do, see Parker's video, because they all handle specific Discover or PRA. Some people within that organization, I know one, are specifically assigned to one credit core collections or whatever, credit core. So you can go to one of my videos and know how to handle, like I've got a great video on how to settle a debt with an attorney, how to settle a debt. There's so many videos that I want to do. And there's so many videos that I've done that I want to redo and add the latest stuff. And I've got this day job that consumes me 60 hours a week. In between that, I do these videos. I look like crap because I don't sleep, and I do videos and cases in my sleep. I'm really 25. Look at me. Anyway, Aaron asks, Brian, should we answer after the validation response date to possibly generate a CA1 violet for asking them to contact you via email? All right, you can't ask them. Well, I know what you're saying. There's a cease and desist component to this. I would tell my client, just say cease and desist. It's the same. You don't want to get into arguing hills you're not prepared to die on, right? So keep it within the violation. So if you want a violation and you know it's coming, have it solid. Don't have a gray area to present the court and say, court, if you just squint your eyes, you can see I'm bullshit. Don't, excuse my language. Just have hills you're prepared to die on, whatever it is. Don't get into these fractions. All right? I hope that answers the question appropriately. I refer attorneys to your videos inside, especially with regard to, the securitization. I, to this day, don't feel happy about my knowledge of securitization, and the maturation of that is that I shouldn't. There's more to learn, but also I'm watching the internet. I know it sounds weird, but you can see it's getting better. It used to be where I could only read financial reports and trusts. I you not. And I would have to ferret out where the loan was. I was in a trial once, and I said it was an eviction case, and they were kicking my client off out of a house for Bank of America. And a side note, 6 of the people on the jury, if I recall, had been evicted. It was like during the heyday, I had a problem with Bank of America, and the guy next to me was not kicking off the right people off the jury. But I'm explaining securitization. This is back in 2010 during the mortgage-backed security crisis. And the judge got off the bench, pulled down the computer from her clerk, kicked her off her chair. And the judge is like trying to find the loan that I was telling her had long gone been eaten by Countrywide or something and lost. She found it, but you only had 3 sources: SEC website, I think it's called Edgar, the financial reports, somewhat, they're better now, of the actual company you're seeking information about, and then just some guy. They had these during the foreclosure crisis. A lot of people were making a ton of money claiming to be auditors. So you could sometimes find their reports as to securitization, which have their place. So now there's so much information to ingest, and I change my answers daily. I'll get another piece depending on who the creditor is and have it locked in right from the source, right in the answer, why it's a viable defense. I'm getting a lot of SHIT lately on that defense because I'm going in harder on it. So my defense of that defense will produce more intelligent, cogent approaches to this that I hope to give you. I hope that answers your question. Oh boy. Do you do any videos on how to handle repossessions? Repossessions, I got 3 videos, but if you're talking about home repossessions, conceptually it's similar, but I won't do, like I said, I went through the foreclosure crisis. And real quick story. I was married to a state legislature later. So at the time of the financial crisis, she was on making the laws. And she said, okay, let's put it this way. She's in a Republican district, but she's a Democrat. And she was trying to keep people in her houses. And we got a 90-day moratorium. And her brother was the foreclosure attorney who had to go down to the state capitol and argue against the bill that his sister was introducing. Anyway, I was trying like hell to keep people in their homes. And the more I came up with, my wife would call me from the state capitol, go, what did you do? Did you blah, blah, blah? I go, yeah. Well, they're down here trying to pass a new law to beat that. And I was going into the 1800s to find a way to keep people. And he'd tell you, I'd get this call. What did you do? So it got so bad. We were doing great. It was keeping people in the houses, and the Supreme Court in Michigan, just in ruling on one small case, an eviction case, decided, I think it's called sua sponte, the expression sua sponte, to just go, you know what, let's talk about these other cases that they've been helping people. One of them is called Davenport. So they just, out of the blue, started picking off all these cases that we were using to keep people in their home. No one asked them. Oh, I'm sure someone asked them in the hallway. And I said at that point, I'm either going to jump off a bridge because I've been doing this hard charging, keeping people in their houses, a great deficit to my sanity and my pocketbook. And I said, I can't do this anymore. So I can't do that anymore. It resurrects it. It makes me feel emotions I haven't felt in a long time, and anxiety through the roof, trying to keep people in homes when I knew the people taking them were falsely doing it. I will tell you a funny story. I started to learn signatures of people that were working for certain banks. They signed for banks as vice president and claimed they owned the house. And there were 3 big robo signers. I started to learn the signatures, and I would see a quick claim or an ownership where a bank says, yep, we own it. Here we did. It was signed. And look up Linda Green if you want to, as far as conceptually about the whole robo signing process. That's the only reason I say that. And I was so good. I saw so many signatures. I could see if it was a false signature or not. I became an expert. And a friend of mine was very proud of herself that her house had been paid off. And she goes, I got the deed here. And it was one of those robo signers. So technically, they never owned the house for her to have bought the house free and clear. It was a robo. My heart sunk. I to this day have not told her that she doesn't own the house, and it's my theory. Not many people do, and I'll leave it at that. So it helps to trace. Securitizations to answer a question is at the genesis of every inquiry as to whether the question is, do you owe the debt? Securitization, I'd say 99% is at the genesis of your question. And you will see, I may look like an idiot right now. I'd say very soon it's going to become the lexicon of, and I'll tell you why. Here's a good reason. Uh, Lending Club, that's a big one. Upstart, Upgrade, Cross River Bank, Blue Ridge Bank, all these banks that are created strictly to provide personal loan products that they immediately securitize after you sign on the sign. Here's a great line from Glenn Ross. After you sign on the line that is dotted. I love that line. So when you sign, and I've seen the transaction reports, I've used the transaction report showing when they say it's not securitized. That's their modus operandum. Here it works. Here's how it works. Here's how those companies work. A bunch of bondholders get together, they create a trust, flood it with money, and then start giving it to these different entities to lend to people. They give it back to the trust who gives the money back. It gets defaulted, it gets pushed out to somebody. Eventually, a debt buyer buys it. A good example of that is Velocity Investments. You'll see they buy a lot of um, Lending Club, Upstart. They buy a lot of Upstart, Cross River Bank stuff. That's so securitized and tranched and different approaches. That is securitization at its worst for the debt collectors. In other words, once the truth is out there, once this gets more academic, more viable, and in the lexicon of this whole thing, there are no debts that are safe from dismissal. The only thing stopping you is a lazy judge. That's it. Um, so the answer, Kenneth, is I stay the hell away from home repossessions, if that's what the context you're asking. But as far as car repossessions, you can put the securitization approach to that. I just did a case with a major California, Westlake Financial. They were telling me, nah, it's not securitized. Not check this out. I was saying, look, this is securitized. Westlake doesn't own it. Yeah, we do. What is securitization? What's that? So a new attorney showed up on the file, and I said, hey, where's Bob? And oh, Bob left. This firm, it's in Michigan. They're the gang that can't shoot straight. If you gave them all guns, they'd go in a circle and point at each other. They're the worst attorneys. They're funny. They're Keystone cops. I love working with them. But it's sad because if you could settle a case in 30 days, it'll take 3 months with them. So a new attorney shows up and she says, hey, what's going on in this case? I said, you didn't send over the financial paperwork. They had. When she sent it, she didn't have, we got to keep shit away from Parker. She just sent me the actual paperwork. And what had happened, all the paperwork that they were proving that Westlake was not securitizing their debt, they'd whited out the bottom of it. And she just was a good person sending me what I asked for. And on the bottom was the actual, she sent me the actual real stuff. And on the bottom, it says, this thing's securitized like you wouldn't believe. Essentially, they had lied. Anyway, this is, geez. All right. So it's there, even in car loans. Kenneth, back to your repossession stuff. I say in some of my videos, the securitization of it all. I really mean that. It's all securitized, baby. Act accordingly. Jeff Bowe says, he's just said some lovely things to me. I can definitely tell your securitization game is getting better just from looking at the materials in your latest video. Yeah, if you look at the older ones, again, I was going through a crisis. I'm getting up in the middle of the night with a broken t-shirt, maybe crying the night before, and I'm talking for an hour and 40 minutes on securitization. Maybe. And by the way, my house is being renovated at that point. Not my house, just a little townhouse. And so there's things falling down. I got paste and stuff in my hair. I'm a mess. I haven't showered. It was a bad time. So yeah, my stuff got better just by virtue of the fact that I got better and we got better. And this defense is going to be the world to you. Put it on everything you do. Okay, Aaron, before leaving, please talk about your gas repo lawsuit. All right. A client lost her car from repossession. Hey, man, if I can go beyond an hour, I'm going to keep going unless you don't want me to. Do you guys want me to stop at an hour? Let me ask you. Somebody say whether they want me to stop at an hour or you want me to keep talking. I'm not hearing anything. I guess this means you guys want me to sign off in 4 minutes. Going once, going twice. Anybody? Beulah, Voodoo Economics. Anyway, a client comes to me and says, "Hey, you got me out of this thing, blah, blah, blah. I just lost my car. Anything you can do?" And I said, "Yeah, man. It's a, what happened?" Yeah, somebody says, "Keep going." Finally, you love me. You really love me. Okay, so the person that runs me in my website and everything just said, "You can keep going." So poor thing has to listen to me, not just today, but all the time. A man in crisis. So I'm happy as hell, by the way. So, client says, "Hey, I lost my car, blah, blah, blah. Anything you can do?" I go, did you pay? No, no, no. She checked off all the boxes why she should have lost her car. I don't mean to say it that mean. I go, so, how am I going to get her out? And this is how my brain, I am a wreck of a person because I'm always trying to fix people. Well, my life would be a mess, but you present to me an issue. I want to fix you. I want to help you. I don't know why. I do know why, but that's another video. And so I'm like, what can I do for her? I love her. I wish I could help her. And she says, I don't know. I may have had the stuffed animal or two or something in the back they didn't return. I go, wait a minute. At the time, gas was $5 a gallon. It was a weird time. And she goes, I said, "Do you have any gas in the car?" She goes, "Yeah, full tank." I go, wait a minute. Everybody has gas in the tank when their car is repoed. It's like leaving $50 on the back seat. Legally, they must return all personal items, especially money, your Billy Joe CD, and your fluffy dice. I actually said fluffy dice in an article that was written. I go, and I'm not sure if I can. Anyway, I sued this bank for every repossession in Michigan in the last 6 years because that's the statute of limitation of the Consumer Protection Act, which used to be good. Now it's crap. It's a huge thing. And a guy wrote a story on it, Brian O'Connor, in the Detroit News, which was at the time a big paper. Now it's an internet site. So the first day, 234 people commented on it. Back when we really didn't comment and all saying what a S-head I am, what an idiot I am, what a jerk I am, a-hole attorney. I got on the list of worst frivolous lawsuits filed in the nation, all this stuff. But I looked and did the research, and gas is a mineral oil. It comes out, it's changed from its original path to now a personal property. And think about it. You got $50 worth of gas in your car. You got $50. You have a right. There's actually and I sued under this, by the way. I sued under this. Check this out. In Michigan, there's a conversion statute that says if someone rips you off, and there's two actually statutes, a common law one and a codified one, you have the right to sue for 3 times the value. So they take 100, you get 300 back, plus you get your attorney fees and costs. So I sued under that, under a really weird, I can't even remember it now. It's like chattels. It's some weird concept I learned in law school right before I again looked, should I jump off a bridge rather than do any more of this stupid property? But I stayed with it and didn't jump off at the bridge. And there was a bridge for me to jump off during law school, and I didn't. So I sued him under this weird 1800s chattels thing and conversion, and it settled, and that's as much as I can say. But I was ridiculed, but it was right on. I researched. I've attached it somewhere. It was fantastic. There's an expression, I don't care what you say about me, just spell my name right. And that's a politician And the last guy to say that, I think, was a guy called Gary Hart that ran for the presidency. And he actually said, "Hey, look, I am not cheating on my wife. If you don't believe me, follow me." They did, and they found him that he was cheating on his wife, and he made the girl famous. Uh, but that's an expression that he wanted the, I guess he thought he can get today, he'd get away with it. But the expression is, as far as, you don't mess with someone that buys ink by the barrel. That used to be the print. You don't mess with newspapers because they could destroy your life. But the, the, the opposite of that is, I don't care what you say about me as long as you spell my name right. And that's someone that wants publicity. So they talked crap about me up and down all over the place. But I got a lot of cases from that, which wasn't my intent. I just wanted to help this lady. I felt bad for her. And I have a deficit in my brain that I have to help people. Someone's calling me the ever ready bunny. That's probably just coffee, but thank you. Testing 1, 2, 3. Testing 1, 2, 3. I lost track of time and I'm late, but I'm here. Lauren Hancock. Lauren, we're just about to sign off. Bye. Just kidding. If you got a question, ask. I think I recorded this and I will put it online somewhere soon. Someone's husband's asked, is credit card statement considered hearsay? Oh, I got a great response to that. If no proof of assignment. Actually, don't bifurcate that question, meaning, I'm going to give you a little tip. Pro tip, I should have a siren going off. Beep, pro tip, call me crazy and conspiratorial, but a lot of these statements are sometimes from 5-10 years ago. 10 years? Yeah. Well, I don't believe anybody's keeping those. And I've had a couple of instances where an old debt and they had statements, and I could see from looking at them that they were sort of off-centered. And I'm thinking, that's weird. Did somebody have their hand on it? And then I'd get my client to go get the actual statement and compared, and it wasn't the same. So that's a freaking great question that you ask from the context of hearsay, because there has to be some proof that, and this is the definition of hearsay, an out-of-court statement offered to prove the truth of the matter asserted. What's the matter asserted? That she owes the debt because she paid on the debt, or she purchased Victoria's Secret stuff on the debt. Believe me, that's a common thing. Victoria's Secret. I see it all the time. They bring, I don't know what's going on, and I hope it keeps going, but it's an out-of-court statement offered to prove the truth of the matter asserted. So unless there's an exception to that rule, that is hearsay. Now, what courts are doing, I don't know why. An exception means it's one time out of 100. The general rule is it's all hearsay, but courts are allowing more stuff in under the guise of a quirky, vague, arbitrary weirdness called 8036, the business records exception. It's in every state. It should be 8036. And they let things in under the business record exception if a affiant either shows up and says, yeah, that's us. I had a case once where the affiant swore under oath that it is what it was. She died. I'm not laughing at that. It made my case easier. I apologize. I got my client out of $25,000 in debt because a person died. Okay, I'm sorry. I'm morbid. But here's why I'm laughing. The debt collector, who you all know, said, that's no problem, and came up with another affiant verifying what the dead person said. I kid you not. I used to sit in court where things like that happen. I go, this is so funny. There's no way the judge is going to the judge is letting it in. You want, who lets judges be judges? So you have to fight against some crazy stuff like that. And I say that in the guise of the hearsay exception rule is an exception to the general rule that nothing comes in, and it better be pretty tight. But they are cannibalizing 8036 business records exception. It's a square it's a square hole, and they're forcing a round, larger, circled fact into that hole. And the judges are right there adding the Vaseline. I'm sorry about the imagery, but that's the way it is. So, hope that answered the question. I'm not sure what all is covered. Where I'm at on my case is the judge approved discovery. Wunderbar. Do I wait for them to send me documents on their own, or do I have to? Great question. Everybody listen. If you litigate your own cases or whatever you do, general rule, number one rule that I insist upon when you litigate, don't let anybody dictate how you litigate. It's your case. Are they going to pay the debt because you let them tell you how to do? Even if the guy's a nice person, he says, hey, just do this, I'm helping you out. Purposely do not what he told you, because don't let anybody tell you how to litigate your own case. That's strength. The minute you start bending because, hey, well, I'm an attorney, you're not, and you kind of get intimidated, that's life, you will lose. I had a trial, great case, federal trial with a federal judge that did not want to do the case because it was a lemon law case. It was a freaking $100,000 RV, and I was a new attorney, new. And he'd go, hey, kid, you may want to get rid of this. And I had like 8 counts. You know what? The jury is going to go your way. I'm down to 3 counts. The jury didn't go my way, by the way, because and I learned, I don't care if you're a judge or an attorney, I'm not letting anybody dictate my case. So that's the answer to that. Don't wait for them to do anything. You have a plan. If your plan is discovery, create discovery questions. I got plenty of them if you want to mirror me. Your call. I don't know what state you're in. Have hills you're prepared to die on. What do I mean by that? If the question goes to the bone, you're going to hear a bullshit response from them. You kind of want that, because if you still are keeping your eye on the fact that the judge is going to be summarying you out, you want that motion compel so you can snooker the judge. Anyway, have a hill you can die on, because if it's an honest judge, present to her a good reason why you asked that question. Here's a good thing to go by. The word question. It's made up of the word quest. You can't have a question without the word quest. So what is your goal behind asking the question? Try to limit your questions to hills you want to die on. And you litigate your case. I want to curse right now. Don't bleeping guy that's telling you how to do your case, or you're waiting for them. Take control. That case will settle right away. If you act strong to these Nimrods, remember, they are victimizers. They look at you with only negative, vicious eyes, because in their mind, you owe the debt. It doesn't matter that they can't prove that they own it. You're the bad guy, even though they're really technically breaking the law. And by the way, they do. I sue them for it. So you be you, litigate your own case. Don't let anybody tell you what to do. Remember, question. The word quest cannot be, you cannot have question without a quest. So have a goal, have a hill to die on. I hope that answers the question. Well said, said Mary. Thank you, Mary. Unless there's any more questions, I'm going to end this now, because it's probably a nightmare for everybody watching. Lauren says, got it. Just didn't know the rules. Hey, man, I learn something every day. I got the 64 review rule. Sometimes I can look at something 64 times. Let's say it went over a year. Okay. And the 65th, and this happens in trial, because in trial, it's sort of like law school. I wish I could be serious about the case the whole way through, as serious as you are when you go to trial. When you go to trial, you better know every single freaking thing about that. And then this is the 64th time I'm looking at it. I'm like, wait a minute. The statute says XYZ. Oh my God, we're going to win. And I didn't see that the first 64 times. When I studied for the bar, they give you these books, and it's serious. You're studying for the bar, encapsulating all 3 years. And then when I learned it, I'm like, I'm learning this 3 years I just took for the first time. I'm like, that's what that meant? Why didn't they just tell us that instead of using the Socratic method and bullying us, making us stand up and embarrassing us because we didn't know the answer, which didn't exist, by the way. So that's the thing with bars and trials. You really have to buckle down. And when you do, and you read it again, you're like, oh, I'm getting really bad now. I'm sorry. Any more questions? Seriously, going once, going twice. Sun's going down. I have to leave soon because I turn into a vampire. All right. I'm calling it. This was wonderful. I hope I didn't talk too much, even though I know I did. I hope there's some nuggets here. And you are really nice to come on board and make say nice things. If nobody shows up, it would have felt so crappy. And I feel good. So, and I hope you feel good. Have you a great weekend. I hope I've helped somebody. Mahaloa. I apologize. Maloa. I mean, goodbye. Yeah, wonderful. We have a couple of people from Hawaii as members and on the community forum. And I always feel I see the sun whenever I see them or read what I just see the sun. Oh, Hawaii says thank you. Thank you, guys. Let me write that down. You are the best. Thank you. All right. I'm going to sign off. Thank you all. Thank you, Cindy, my wonderful editor. Could not do it without you. Thank you. And I couldn't do anything without you. And I swear, I mean this. Your thirst keeps me hungry. Your wanting to know stuff. I got 30 years of nonsense up here, but it's actually valuable stuff. And I get to give it away instead of just dying with it. So here you go. I got to go. Thank you all. Aloha. It doesn't mean goodbye. So we'll talk soon. I'll do another one of these soon. Okay. See you on the other side. Bye-bye.